Yeah, please, Lord. I beg to mention item number 10, my lord. My lord, Lordship may kindly pass it over for the day and fix it on my Thursday or Tuesday, my lord.
It goes after a week. Item number 10.
10, my lord.
This after a week is paid for by land council. Outside the representative.
All right, my lord.
Outside the. After a week is paid for.
May please, your lordship. Lordship, I beg to mention item number 6, lordship. Culinary matter may be taken up next week.
Same order. Item 6.
Obliged, lordship.
May I please, your lordship. Lordship, I beg to mention item number 3, lordship. Matter may be taken in another 6.
Okay. So
Interim was got, dear lordship. Interim was there, lordship.
interim extended.
Obliged.
May please, lordship. Lordship, I beg to mention item on 8 and 9, lordship. Lordship, we have some personal difficulties. Lordship, kindly matter will be fixed on next week any date, lordship.
Then we'll have no work at all. Mr. Roy, you are in trouble. If everybody takes an adjournment, we'll hear you, whether you have a case or not. Okay. Item
8 and 9, lordship.
But all 2017 matters are being adjourned
Lordship will give a very short date, Lordship.
Okay, lordship.
after a week.
Yes, Lordship.
Yeah,
After a week.
much obliged, lordship.
In one of these cases where they are where they are taking adjournment, file an application for modification of interim order. Do it in one case.
Lordship, in some courts,
Not that,
adjournment was given only on cost. So adjournments had stopped.
foreigners tribunal, these people. General impression is that they are poor people, they are uneducated.
No, that was the only reason to stop adjournments, Lordship.
File an application in one of these cases as a test case. As a test case, file an application in one of the cases and then you do it judicially.
But if it-
Okay.
Much obliged.
Interview.
Daily list item 1 for admission.
May I please, your lordship.
One. One.
Is the key is 3, 6, 8, 9.
Yes, Mr. Ahmed, how did you, how are you connect, how have you connected yourself to your parents?
Well, there's a land
Except
document.
for the, this.
Now, my lord, the reason that has been mentioned by the learned member of the tribunal, my lord, this is absolutely absurd, my lord. If your lordship can you turn to page 42, my lord. Impugn order.
42.
Page
So
42.
shows from the document, we will not examine,
Yes,
we will not
please.
examine this.
Right.
It may be right or wrong, but it shows how you have connected. You have shown a copy of Jahabandi.
Annexure 1 is page 11, my lord. That is the Gavuna certificate.
Huh?
Annexure 1, page 11, my lord. that Gaubara certificate. The state emblem is there, my lord. But the Gaubara had deposed, my lord, in favor of me. The contents were proved, my lord, and that was admitted by the member of the tribunal. Annexure 11 is the first annexure. Annexure 1, my lord, page 11. There's a vernacular, page 10 is the.
Well, you've seen the interpretation of section 50 of this, of the Evidence Act in these cases. He does not have the special knowledge. Section 50 would not apply of the Evidence Act. Have you examined section 50?
I have seen, my lord, I've done.
Because he must assert how he has this special knowledge.
Even, my lord, leaving apart this, my lord, particular Gaubara certificate, my lord, the voter list of 1965, it relates to, my lord, the land documents also. My lord. My lord will kindly find at page, my lord, 12, my lord, the voter list of 1965 of his father, my lord. Page 12, annexure 2, my lord. Father is Jahed Ali, and the village, my lord, seems to be Lengriburi, my town. And grandfather is Jabor.
Langri Borigaon. Yes.
Yes, Lengriburi Gaon. Now, if your lordship kindly turn to, my lord, page 21, the land document, my lord. I inherited land from my father, my lord. Page 21, my lord, is the vernacular. Annexure 4, my lord.
Yes, which is the entry?
Same village, my lord. In remarks column, my lord. Go, my lord.
Go.
Go, my lord. Page 21. সরজমিন চিঠাৰ চক্ৰ বিষয়া মহোদয়ৰ ইমান তাৰিখৰ হুকুম মতে পতাৰ 509 নং দাগত 1 নম্বৰ স্থলত মোহাম্মদ আৱাল আজিজুল হক আব্দুল মন্নাস খতিজা খাতুন হাজেরা খাতুন and number 10 is my name, my lord, জুবেদা খাতুন পিতা জাহেদ আলী নামে নামজারি হয় ওই তারিখৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে 6 নং স্থলত মন্নাসৰ স্থলত থাকে my name is there, man. I inherited land from my father, my lord. And this Jamabandi, my lord, it pertains to, my lord, same village, Lengriburi Gaon.
What is the date of death of your father?
Date of, my lord, date was not mentioned, my lord, in the deposition, my lord. She said, my lord, some 20 years back, my lord, suppose.
You see, the difficulty is
My lord.
that the inquiry
Yes, my lord.
was initiated in 1998
Yes, my lord.
and the verification report
Yes.
is prior to that, that is 1910, 1998. This. 98 or something, I can't read properly.
98, my lord.
It's 98. 1910, 1998.
ERO's report, my lord, it reflects that it was carried out on, my lord,
So that's okay.
97, my lord, 24/7, 97.
Maybe the date I can't read. It's 97 or 98, I don't know. Annexure B to
And
the
Hector B is the ERO's report, my lord, 24/7, 97.
97.
97, in serial number 4, my lord.
I take it 97. Now. Now thereafter comes this entry in the Jamaband in the year 2002. That means it's a post-inquiry document. Is a copy of the order available of the of this authority? Who's Chakra Khan?
In fact, my lord, the annexure A, if your lordship, my lord, kindly compare annexure A along with the reference, my lord. The village name, my lord, seems to be different, my lord. In the reference, my lord, the village name has been mentioned as Tatigata. And in annexure A, page, my lord, 25, the LVO's report, my lord, the address is shown as Tatigata Pothar, my lord. Contradiction is there, my lord. If your lordship compare, my lord, the inquiry report along with the, my lord, reference.
Tatikata.
Tatigata, and that one is Tatigata Pothar. Both two are different villages, my lord.
I don't think there are two villages because in annexure B of the format,
My lord.
again it is Tatikata.
Yes, my lord.
No, Pathar is not there. So I think interchangeably they are using Tatikata and Tatikata Pathar.
My lord, the Tatigata and Tatigata Pathar, my lord, I had, my lord, some several cases, my lord, from this particular area, my lord. And it was mentioned by the concerned Gaur that these are two different villages. My lord.
I don't know. Look at this. This is your cross-examination. You
Right.
yourself have given the address of Tatikata Pathar.
Yes.
So that means it is interchangeably used.
Actually, my lord, it should have been Tatigata Pathar.
No,
She
whatever
got
the-
married,
but
my lord. Not in
Since
Tatigata.
you're giving
But
that,
in the, my lord, LVS report, it was mentioned rightly as Tatigata Pathar, but in other reference as well as the ERO's report, my lord, that was wrongly mentioned as only Tatigata.
Your PSN district is same.
we don't know because
Yes, maybe so, but the
PSN
village are different.
Yeah.
Two different villages.
because unless you project documents before us, we won't know. Right? We don't have personal knowledge of
Actually,
Tatikata
what
Pathar.
happens in these cases, my lord? In number of cases, my lord, I have
No.
personally, my lord,
Don't
entered.
tell us a general statement. If we go by the general statement,
Well,
many things may crop up. We don't know. Be specific because this is a litigation of a person. He says that the two are say different villages as instructed to you. So if it is two villages, you have to show us that it is two villages. Personally, we don't have knowledge. Tatikata Pathar. I don't think if I say Tatikata Pathar, any of the lawyers in the room will be able to identify that
if I
place.
produce, my lord, the
No, it's not that.
certificate of concerned Gaur, my lord, Hill, my lord.
No. You see,
will be the
one-
executive authority.
Mr. Ahmad, we are over one stage.
My lord.
These things of this LBO and all, these were never questioned in the tribunal. So in a rate proceedings, the scope is even lower.
Yes.
So for the time being, we concentrate on whatever materials are there on record. Because this is entry in the Jamandi is a post inquiry document. So we don't know how the names have entered. The order of the circle officer or the assistant settlement officer, those are not before us. So therefore, the basis on which that has been mutated, we don't know.
But that was inherited by the proceeding, my lord, prior to my lord passing of this impugn order.
Hmm?
Probably, my lord, the prior to passing of the impugn order, my lord, the land was
Oh,
inherited by
definitely,
the
it's
proceeding.
post inquiry. So at that time, there is no document. Now comes the inheritance. By inheritance, you are trying to project that he is my projected father.
Linkage is clear, my lord, in the documents. Name was wrongly mentioned, although my lord, the grandfather's name.
Power deposition notice. Power deposition. Lordship,
It is already there. We admitted and fixed it for hearing after a month.
Lordship can do that, but we have also prepared, Lordship, I would like to just submit some points on it. The Gaumbura certificate which my friend is relying on, and he says it is proved, Lordship, at the time of deposition of the Gaumbura. Lordship will come to page. Like it. The age of the Gaumbura at that time, at that point was 56 years, Lordship, and that means he was born sometime in 1961. And the proceedee relies on the voter list of 1985, and according to materials which are there in the writ petition, her age should be of 40 years at that time, Lordship. So she was born sometime in the year 1945. So the Gaubura is 16 years younger to the proceedee, Lordship, and whatever evidence he has given, it is only a hearsay evidence, which has no value. The document on which my friend is relying on it, Annexure 1, Lordship. And then
Have you heard of that girl? I think she's a girl. 7 years of age. She can recollect the happenings of the previous year, could identify the parents.
there's
of
so many such
earlier
reels
life.
all over, Lordship, nowadays.
No, but he could, she never visited a place, she could identify, she could give the year of death. Year of
Some
year of
superpower
birth.
she must have possessed, Lordship.
I don't know, it's available in the internet.
Yeah, that is what I said. On online, we get lot of stuff these days.
When I don't read law, I read all these things.
So that is one point which Lordship can, which we are submitting, Lordship. And
Please come
then,
to that deposition.
yes, Lordship. So page 39, Lordship.
Page 39,
Yes, Lordship.
56 years
Yes. He says 56 years,
in 2017.
2017. And his thing is, I know the OP, namely Jubeda Khatun. She is from my lot and near to my home. The OP was married to Tatikata village. The
She is
name
born
of,
in 1951.
yes. And then the proceedee is relying on the voters list of 1985, Lordship. Yes, Lordship. Bambura says thirty kata.
Here also is 30 kata.
No, and
LPS
voters
is-
list is thirty kata patha. Your procedures,
কোনো contradiction আছে?
contradiction है patha মানে patha है থাকিব
আপনার produce করে লেখেন। এটা বেলেগ।
হয় নেকি?
Hmm.
But it is your opinion to think. You are relying
Yes,
on.
I understand.
See what?
46 years. Son is 36 years old. Permanent. Previous year of Natal Beer Holiday.
Tarka?
Next page.
Idea হব লাগিব।
Natal.
মইতো 9 বছৰতে বিয়া দিলো।
My son was born after 3 of phenomenal age.
So আমি তো ঠিকে ধৰিছো।
কেনেকে ধৰিব এইটো? This kind of presumption.
No, but this is 40 years here.
I understand, but you see the reason that has been mentioned by the number.
But we'll go by the documents,
We go by the observations.
whatever suits you. ये कैसे 78 she's 60 years. Right, but she's relying either she is wrong or he is wrong. Either the document is wrong or the application was wrong. That means. This document is wrong and what he's saying is right. Proposition মানে wrong হলো মানে না খুবই এটাই মনে না দিব পারে 60 years 2017 or 60 হলে এটা ডকুমেন্ট গুলো কিমান হব তাই যদি 85 or 40 আছে
6 of that are first putting.
and যদি 60 years এটা একটু ঠিক আছে না in 1966 as it yati 1957 grace I will not get over this crisis. It has been 28 year 1977. 1997, died in 97, mother 91. After married 36 years, I commission married 37 years before in 1980. Still very father's residence, very father.
Ms. Verma,
Yes, Lordship.
to you and to Mr. Sharma or any other counsel who is appearing for the FT and home, we have a query.
Yes, Lordship.
I think this, that query we will not say in the open court, but if you can just make it a point to meet us in the chamber at 1 o'clock,
Yes, Lordship.
because the question which we have in our mind can lead to many other consequences. I mean, so that's why your input means that we want your input both as for the home as well as from the point of view of revenue. So these two things we have a query. You can just find time to be at 1
Lordship,
o'clock when we
first will come.
take a recess. We have a query. So for this purpose, we are adjourning this to 2 o'clock. We take it up at 2 o'clock. There is a query report. We want a clarification. We are reserving to not ask the query in the open court. The reason for that. We have only 2 or 3 matters. If we rise before 2, then maybe when after we rise. we have that.
Lordship, we are in court only, we'll come.
Supply item 11 for admission.
Oh, this school education matter.
Yes, sir.
Who's appearing for school?
Government.
Give us call for school education. SC, school education.
Secondary education.
Huh?
Secondary education.
I don't know. We have recorded in the last orders, school education.
Mr. Mujumdar was appearing last.
Last time Ms. Terangpi was here.
Thank you.
Yeah. She took time.
She took time. So whether they have done the exercise or not. This school education, school oblique, secondary education, school oblique, secondary education. Yes, in the meanwhile you proceed.
My lord. My lord, this petition, writ appeal has been deferred against the impugned order. Lord, you'll find a case,
What was your position in the writ petition?
my lord.
In the writ petition, who are
In the
you?
writ petition, my lord, I was my appointment was as in-charge principal was challenged by the private respondent, my lord.
Okay, you are, in the writ petition, you are respondent number 5.
Yes, my lord.
Okay.
I was appointed as in-charge principal of the school, my lord. That was put to challenge by the private respondent here in my lord.
What is the name of the school?
School name is, my lord,
She has come.
Paschim Borigok Thiridatta HS School.
Daniel, she has come. Principal, what is the name of the school? Please come again.
Paschim Borigok Thiridatta HS School, Nalbari.
Yes.
The writ petition, my lord, my appointment was challenged as in-charge principal. That was finally, my lord, in the impugned order. my
Mr.
lord.
Roy, the third word of this school reminds of a different personality. That is why you both are here. No. Yes.
My lord, by the impugned order, my lord, my appointment as in-charge principal was set aside, directing the authority, my lord, to appoint an in-charge principal, my lord, by following the process prescribed under Rule 12 of the service rule. my lord.
As per the uh, gradation list, what is your position in the school?
In the gradation list, my lord, my position is second.
Second.
You also will find the gradation list at page 64,
No, we don't disbelieve you.
my lord.
Gradation list of which year?
It was, that is not there, my lord, just before appointment of the
Okay,
petitioner,
just
my lord,
before
Praveen,
appointment. Okay,
it was,
gradation list, you are number 2.
my lord.
And Mr. Roy is?
One. This gradation list is also under.
So I believe that is the ground on which the learned single judge interfered.
Yes, my lord. This gradation list is also under challenge, my lord,
Okay,
in a different proceeding, my lord.
in the writ petition, the gradation list was also a challenge.
No, my lord.
Okay,
He was senior, my lord. He was not required to challenge this gradation list, my lord. So, my lord, the writ appellate hearing, my lord, he has challenged this gradation list, my lord, by different writ petition, my lord. On the ground that, my lord, my basic challenge is that, my lord, he was initially appointed as, my lord, graduate teacher on ad hoc basis. His service was regularized, my lord, in the year 2010. Prior to that, my lord, his service was extended on ad hoc basis only, my lord. So, my lord, the period prior to regularization.
just a moment. Mr. Rangpi, with regard to the finding at paragraph 25, the observation at paragraph 25 of the interim judgment. Please read that.
Having regard to the submissions of the learned counsel for the respondent number 5, that the petitioner has obtained the B.Ed degree and M.A. degree simultaneously from 2 different institutes without due permission from the competent authority under the rules, and the respondent number 5 has already made a representations against such degree, which is yet to be considered by the respondent authority. Such submissions are considered only to be rejected in view of the conclusions rendered herein above, as noted above, until the time the degree obtained by the petitioner is held to be invalid or not genuine by the competent authority. This court,
No, what is your
can-
department's stand on this?
Your Lordship, we are yet to receive the instructions regarding this, Your Lordship.
That means your officers don't work. There is a writ petition, there is a finding of the court. And we are in a writ appeal. But you don't take a decision.
Your Lordship, a last chance may be given to us, Your Lordship. On the next day,
No question of license, we can give license to people who want to work.
My lord, there stand what you will find at page 89. A
Page 89.
similar case, my lord.
Huh?
In a similar case, my lord, they have, my lord, decided not to consider those degrees. In a similar case, my lord, page 89, my lord.
Please come to that finding.
Finding what you will find. Page, my lord, 90, my lord. Page 90.
That has been stayed by the High Court, my lord. That has been stayed by the court.
Mr. Karita, if that is state, then there's no chance of any
No, no.
interference by the appellate court in
My lord,
this. in your writ petition.
stand of the government, my lord.
No, but this is okay. That stand was interfered with. That's
Yeah.
what Mr. Roy says. I don't know whether. But the effect would be that the stay operates to your disadvantage.
But in view of the learned single judge decision, my lord, in the other proceedings, my lord, wherein, my lord,
Just a moment, just a moment. Yes, Mr. Anki, in terms of order dated 1/2/2023,
yes, Your Lordship.
was any order passed? Because this order of 17/11/2022, page 89, was interfered on the ground that somebody else heard the matter and somebody else decided it.
Decided, yes, Your Lordship.
So therefore, natural justice are not complied. That is the finding. But this, from this judgment of the learned single judge, it appears that the director of secondary education would take a fresh decision. Now, is it passed?
No, Your Lordship. No.
To my knowledge, they have not taken any decision, my lord.
So therefore, we are on the first issue. I give time only to people who want to work. Now, if you are director secondary education, we can only draw a parity with one of the mythological figure in the Ramayana. Names I forget, but I have heard, I have read that he slept for 6 months. So those mythological figures still exist. Is it not? You please move out to the corridor, have a call, and then please come back. If any order has been passed,
Yes, your
you
lordship, I
take
can,
this.
yes, your
You
lordship,
take a copy of this.
yes, your lordship.
In fact, there is a short issue, my lord. They have not taken the seniority issue while in the, before the single judge. Now they prefer to appeal, taking that issue, my lord, the seniority issue.
No, that's okay. We'll come to that.
Yes.
Because when right now the mind is occupied by something else. Because if this issue, what you call the seniority position has been given a go by, and then the degrees obtained without permission has been accepted, then then this what you call situation changes. But if the stand of the government remains that the degree obtained without permission will not be given any preference, then Mr. Saini
That is
succeeds.
in two of the judgment that has been interfered with, my lord. The degree obtained has a valid degree, my lord.
Has a valid degree.
Valid degree, my lord. That is Moshmi Kalita and there's another two judgment. My lord. That has
Single
not been,
bench decision.
right till now, state has not gone for appeal also against that. That has been decided, my lord.
Okay.
I give the judgment, my lord.
Basing on those judgments only, my lord, this impugned judgment was delivered. Basing on earlier decisions, my lord, this impugned judgment has been delivered. The single judge decision, my lord, lordship may interfere with, my lord. There is no doubt. My lord. I have put to challenge this impugned judgment, my lord, on my lord, two grounds, my lord. Basically, my lord, first of all, my lord, he was initially appointed on ad hoc basis. His initial appointment was on ad hoc basis. Page 40, my lord. Page 40, my lord. Initially, he was appointed for a period of 3 months, my lord, on ad hoc basis. Very short.
Yes.
Then, my lord, page 42. This is the first extension, my lord. After completion of 3 months, my lord, for another period of 3 months, it was extended. It was extended with effect from 18/12/98.
Which is the service rule which is being followed for appointment of teachers in higher secondary school?
My lord, earlier, my lord, at the time of their appointment, my lord, it was 1982 rules.
1982
82
rules. According to this 1982 rules, whether the inspector of school was a competent authority to appoint?
No. My lord. Assistant teacher, my lord, inspector of school was, my lord, competent authority.
Competent.
Assistant teacher. The subject teacher was appointed by the director and the assistant teachers were appointed by the inspector of schools. But Lordship will find the first extension order.
Just a moment.
My- Education service to me. Secondary education. I'm sorry, secondary education. Secondary schools. Last of all, Miles. Assistant teacher.
Calculate page 790.
Yes, 793, my lord.
Yes. Now, assistant teacher is which grade?
Graduate teacher, my lord, grade 4,
Grade 4.
my lord.
Grade 4 is graduate teacher.
Yes, my lord. Assistant teacher is graduate teacher, my lord, in high school and high secondary schools, my lord.
So grade 4 is inspector of schools.
Yes, my lord.
Okay. Yes.
My lord, the initial appointment was on 16 September 98. For a
15th
period-
September 98.
98. And it was for a period of 3 months.
Yes.
3 months ends on, my lord, 15th of December.
Yes.
And first extension loss will find it was extended from 18/12/98. Page 42, my lord.
Yes.
Meaning, dear my lord, there is a break of 3 days.
We can't say whether it's a break or not, because there are many judgments even of this court
Right.
where the artificial breaks is no break at all. So for the time being, we are not making an opinion, but please proceed.
My lord. Next, my lord, loss will find the second extension as per his document, my lord. It was submitted by the writ petitioner only, my lord, page 44. This was, my lord, of 13th August 99. Though, my lord, there is a reference of, my lord, an order dated 12/4/99. That order was never placed before the court by any of the party.
Yes.
And the final extension loss will find at page 46. It was extended until further order.
Yes.
Ultimately, my lord, without regularization of his service was confirmed by the order at page 75.
It's 75.
Page 75, my lord. His service was confirmed along with the appellant and the other 2 persons, my lord.
No, but so far is the first statement that there is no confirmation.
No, till 2010, my lord, there is no confirmation, my
No,
lord.
no, that's okay. But we find, come to page 40.
Yes, my lord.
As per page 40, on recommendation of the district level selection board,
Yes,
that means some process of selection was there.
but it
so
was
for-
ad hoc, my lord, that order
No, no.
he was accepted.
No, no, you see, from our little experience we have gathered, every appointment order says temporary appointment. So
will
even,
also be-
even temporary or permanent, it's a post within the meaning of civil post within the meaning of the service rules. So once there is a selection process,
My lord.
question of confirmation is merely an administrative way to,
No, my lord. His initial appointment was ad hoc appointment. In the
No, no,
order
we
itself,
don't
my lord,
know.
it says.
nobody's, we don't know. Nobody, I think nobody has questioned that the selection itself is illegal. That's never the,
My lord.
never the issue raised.
Page 94 is my appointment, my lord.
So at that point of time, the authorities deemed it appropriate to extend, to give a temporary appointment. But it still
Of the
constitutes a
same
civil
year, my lord, I was appointed after 1.5 months.
page,
Page 94, my lord.
page 94.
My lord. In my appointment order, my lord, there is no mention like ad hoc and 3 months, etc.
Yes.
Had he not been appointed, my lord, on ad hoc basis, he should have challenged this his appointment or initial appointment order, my lord, if he was regularly appointed. But he never challenged that order. It was extended from time to time, and ultimately, my lord, in 2010, his service was confirmed. So, my lord, prior to confirmation of his service, he cannot claim seniority over the regular staff. My lord, on the point of seniority of ad hoc employees, my lord. My lord, on the point of seniority of ad hoc employees, my lord, that is Central Council for Research in Homeopathy versus Bipin Chandra Lakhera, paragraphs 9, 10, and 11, my lord.
Okay. That was very fast. Thank you. No, that's okay. You've been exemplary fast. Thanks for that. Yes.
My lord, on the point of seniority of ad hoc employees, my lord. Paragraph 9, 10, and 11, my lord. Of 2011, 15 SCC,
11, 15.
15 SCC, 5,
Which
6,
paragraph?
9, 10, and 11, my lord.
Can we come to paragraph 4? Second line, there's a word,
Yes, my lord.
correct? Okay. So for the time being, we are omitting this paragraph 11. Now, second,
Second judgment is, my lord, C.H. Narayana Rao versus Union of India, my lord.
yes. Here also in the, there's a head note. I have not gone into, but the head note,
My lord.
second line.
Yes, my lord. Stop the participant, my lord.
No,
Not
second line of the head note, first head note.
where initial appointment is only ad hoc, not according to rules. Yes,
So here we have shown you, you'll have to demonstrate that the selection process was not there.
is
Page 40 refers to a selection process. It says that a recommendation of the district level scrutiny committee is a selection committee.
My lord.
So this selection committee does not give recommendations without there being a selection process.
He never produced the select list and all, my lord, in his.
No, that's
recommendation.
okay. But we find there is something. So therefore you have to overcome that part also. And the court has to determine if there is a selection process, then the appointment came. So
Right.
therefore this finding not according to the rules. This is a point which is required to be examined.
My lord. Then, my lord, also may call, my lord, ask the state council, my lord, to.
No, we will
Well,
come to that.
advise
I
that
was
to-
just trying to understand. Because from foreigners bench to this education branch, unless I educate myself, even in the next hearing, I'll be in the square one.
My lord, my simple case is that, my lord, he was initially appointed on ad hoc basis. His ad hoc period cannot be counted towards
So
seniority.
we are serious about it because of your challenge. You said that in the writ appeal, you are making a challenge to the seniority position in the A gradation list.
Yes,
That's what you said. That is making us seriously examine this,
yes, my lord.
this issue.
By the writ petition, my lord, with WPC number 3544 of 2024, my lord. 544 of 2024, my lord. Notice has been issued in this case, my lord.
Huh?
Notice has been issued in that case, my lord.
Okay. WPC
3544 of 2024,
This is a challenge made by you.
my lord.
Initial order passed in WPC 3544 of 2024.
I have the
Oh, you have a copy? Okay, no, it's available.
My submission is that
That is perhaps the only point.
that is one point, my lord. The
Okay.
other point is, my lord, his degree, MA degree, my lord. He has obtained it, my lord, without permission of the state in violation of Rule 13 of the Conduct Rules.
13.
Rule 13. So we'll find it in the Assam Services Manual. 13 in my book, 101.
We are retrograde. We are in page 95.
Whereas my book is later edition.
I just need an opportunity to smile, nothing more.
No government servant while in government service shall join or attend any educational institution for the purpose of preparing himself for or shall appear at an examination for a recognized university or university without obtaining previous permission from the appointing authority.
But Mr. Saikia, we have a query.
my lord.
In this case, Mr. Roy acquired a MA degree without permission.
Yes.
And you say it is a misconduct within the meaning of Rule 13 of the Conduct Rules.
My lord.
Now, the government, in all its wisdom, did not draw up a departmental proceeding
My-
against the respondent.
Yes.
Now, what would be the effect? The Rule 13 does not say a degree acquired without permission will not be will be non-est. So the government does not de-recognize
government-
those degrees.
Government cannot, my lord, invalidate those degrees, my lord.
No, it's
If
not a
degree
question of
is, my lord, offered by the university, they cannot, government cannot, my lord, invalidate it. Government may decide that they will not honor those degrees.
no. That also power is not there. The only
My-
power is to draw up a decree and a departmental proceeding or a disciplinary proceeding and terminate the service
My-
for misconduct. For everything which happens in a government, the only remedy is to draw up a proceeding for misconduct.
Lord, they have in their own, my lord, they have taken a conscious decision not to honor those degrees. Not to accept those degrees, my lord, for the purpose of seniority, my lord, promotion,
Is it?
my lord. In the or similar order I have referred to, which my learned friend has said that, my lord, this honorable court has stayed. That was the decision of the government, my lord.
Again, a supplementary question, Mr. Saikia.
My lord.
Under the discipline and appeal rules, the nature of punishment is prescribed,
Yes,
correct? And when we read this Rule 9, please come to that. Seven or nine, the punishment is at 7 or 9. Where is that? Major penalties.
procedure prescribed in
Nine.
Rule 9, my lord.
Huh.
Rule.
So these are the,
Punishment has
these
been
are the,
prescribed in Rule 7.
huh?
Punishment has been prescribed in Rule 7, my lord,
Rule 7.
my lord.
Nature of penalties: censure, withholding of increments, recovery, reduction to a lower scale, compulsory retirement, removal, dismissal.
Yes.
Where is the power to uh, to to not honor the degree?
That is, my lord, prescribed in, my lord, Roman 2, my lord, withholding of increments of promotion.
No, that's okay.
Fine.
That's okay. You do, the government will do whatever is prescribed under section 7. There's no quarrel with that.
My lord.
The query of the court is somebody obtains, you see what happens in a, we will just try to draw a parallel. Somebody is accused of amassing assets disproportionate to his known source of income, and process is initiated against him under section 7A and 13, 1 or 13, 1AB
Right.
or 13(2) initiated. Now, under the Prevention of Corruption Act, there is a provision which entitles the state to seize that property, attach it, seize it, and then to appropriate it, being the ill-gotten proceeds.
Right.
That authority you have, it is there in PMLA, it is there in the other penal sources. Now, this is a disciplinary proceeding, is a civil proceeding.
Yes.
Now, in a civil proceeding, unless there is a power of the government to, so if somebody acquires a degree without the permission of the appointing authority, he loses his service or he gets penalty as prescribed under section 7, rule 7. Now, the rule 7 does not say that the degree is invalid.
Doesn't say, my lord.
So can the disciplinary authority impose a punishment which is not prescribed under section 7, rule 7? I'm just asking because you will know our limitations in service law. So therefore we are asking questions.
My lord, they can stop the promotion. They can
No,
stop the
that you
promotion.
do it. If the government wants, please do it. We'll be very happy. Do it. But unless that is done, can we have a draw presumption in the writ petition or in this writ appeal saying that this is a degree which is de-recognized? For that, there must be some enabling provision which allows an employer to de-recognize the degree which has been conferred by a competent authority.
They cannot recognize the degree, my lord.
Then
They cannot recognize. Once a degree is, my lord, given by an university, the government cannot recognize it, my lord. Government may not honor that degree, my lord, if it is, my lord, obtained in violation of the conduct rules.
but no disciplinary proceeding is drawn up against Mr. Roy.
No.
So therefore, that punishment is a distant dream.
Some lacuna is there on the part of the government, my lord. They have decided, my lord, in the
But
road,
not
my lord,
lacuna, we always draw a parallel from our ethics. I referred to someone in Ramayan.
yes, my lord. 6 months.
One can wake up a person who is sleeping. They did so in Ramayan. Person who is sleeping can be woken up. But if a person is daydreaming, very difficult to wake them up.
So, my lord, after retirement of the earlier principal, while my lord, seniority list was placed before the government for appointment of the, my lord, in-charge principal, government considered all these aspects, my lord. And because of that, perhaps, my lord, I was appointed as in-charge principal. And I was not appointed as regular principal, my lord. I was appointed only as, my lord, in-charge principal.
How much time would we take to appoint a regular principal? Any idea?
They have, my lord, so far my instruction is concerned, my lord, in Nalbari district, my lord, they have prepared the gradation list. Seniority list they have prepared. Nowadays, my lord, the seniority is, my lord, amongst the district. Earlier, my lord, it was, my lord, school-wise seniority. It was considered school-wise seniority. Now, my lord, district-wise seniority is considered. And
For appointment as a regular principal.
my lord.
Okay.
So, my lord, they have prepared
So
the
that
district-wise
means,
seniority list also.
But I read somewhere that the post of principal is not a promotion post.
For the purpose of headmaster, my lord, they have prepared the gradation list. I'm sorry, my lord.
Okay.
For principal, my lord, they can advertise any moment, my lord. The post of principal, my lord, they can advertise any moment. It is a direct recruitment post, my lord. It is not a promotional post.
As judge principal. Okay. We proceed to hear Mr. Roy then. Any other point?
These are the 2 points, my lord.
Okay.
These are 2 points.
The Lordship will take first, my lord, the stand of the government, that is Director of Secondary Education, page 97, my lord.
Okay, just Mr. Roy, before you will hear Mr. Rongpi. Mr. Rongpi, sorry. Because of the stand of the government, you have to take some. Then we'll come to you, Mr. Roy.
Yes.
I have received their instructions, Your Lordship. I think I
Yes, we have seen that.
need to order against. But
And we appreciate your promptness. Yes.
So I'm yet to obtain the instructions regarding para number 30, Your Lordship. So I may need some time, Your Lordship.
Para 30.
Yes, Your Lordship. Para 30 and 25, 28, 25 and 30, Your Lordship.
That is the, my lord, final outcome of the.
Para 30 of the.
That is in.
No, this is not very important for us for the time being. Because this would be appointment of a regular principal. Now we are in the midst of being an arbiter to the dispute for
Seniority.
ad hoc principal. So I'm saying about arbiter because now we are in Olympics. The boxing, wrestling, the chief umpire is called an arbiter. So now that's why we are using that term. So in this case, what would be your stand? You filed an affidavit in the writ proceedings.
Yes, page 97, man.
That is page 97.
That's all. Para 5.
Hmm.
What is the stand?
Lordship may come to para number 5, Your Lordship, page number 98.
Please tell us.
That the deponent beg to so that the following basis which have not been placed on record by the petitioner for the purpose of disposals of the instance writ petitions, Your Lordship. On the retirement of the existing principal of BP HS School under Nulbury District on 31/3/2023. The inspector of school by his letter dated 22/2/2020 submitted proposal for allowing next seniority most qualified teacher for the school to hold the charge of principal with effect from 1/4/2023. On verifications of the seniority list of the said HS school, it was found that the writ petitioner Sri Kalyan Das is the senior most teacher of the school as per date of receiving graduate scale of pay, that is 1998, Your Lordship. As per the Assam Secondary Provincial and Service Rule 2018, master degree and BT degree are mandatory qualifications for holding the post of principal for provincialized schools. That the writ petitioner Sri Kalyan Das, graduate teacher of the said school, acquired master degree in arts from idle in distance mode in the year 2019-2021 without obtaining no objection certificate from the appointing authority. He obtained no objection certificate from then principal of the school, which is not permissible under clause 13 of the Assam Service Rules 1965, which is quoted under herein. No government servant well in government service shall join or attend any education institute for the purpose for preparing himself for or shall appear at any examinations for a recognized board or university without obtaining previous permissions from the appointing authority. In view of the above, the master degree acquired by the writ petitioner is not found as per rules, though He was the senior most only on the basis of receiving graduate scale pay, that is 1998. His case was considered for allowing him to act as principal in charge of the said school. That on the other hand, see Narendra Chandra Dekar. That's point number 5. Graduate teacher of the same school who was receiving graduate scale of pay with effect from 6/11/1910, who acquired MA from Guwahati University before joining his service and obtained BA degree on being duly deputed during his service period was considered and in preference was allowed to hold the charge of principal of the school-wide impugn order dated 3/3/2023, Your Lordship.
Just a moment. Mr. Hazarika, is there any decision of this court on the issue like this, that the degree obtained in the absence of the previous permission from the appointing authority, that degree has been held to be invalid? Any decision of this court,
No.
to your knowledge?
No.
Okay. 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 Anything on the question of law you want to address us?
Lordship, today I'm not prepared.
No, please be prepared. You have a long way to go. And you must also understand the code better than you know the law. Because in this matters, if you want to take an adjournment, I have been telling you all the time that take the adjournment at the first blush. If you spend the time, then we decide it. There's something running behind you.
Yes, Your Lordship.
Correct. We, over this, we don't have control. Okay, yes, Mr. Roy, then.
There's a break, my lord.
Let's take a
Break,
10 minutes break, my lord.
Oh, yes. Thank you for reminding us. Take a break and come back. Yes.
Lordship, Lordship has already seen that affidavit of the Director of Secondary Education, my lord, which is clearly reflected that, my lord, the petitioner is the senior most teacher, my lord. That is page 99, my lord.
Yes.
Now, Lordship will see prior to that, my lord, see page number 68, my lord. The executive committee, my lord, of PP Datta Dhir Datta Higher Secondary School. There's a resolution, my lord, but that has not been acted upon, my lord. Resolution number 3, page 68, my lord.
$58,
68, my lord.
68.
I have made a type copy of proposal number 3, my lord. That today it is decided in the meeting that senior most teacher, Mr. Kalyandas, possessing graduation and BA, will be taking charge of the school as principal from 1/4/2003.
Yes.
Now lordship may come, I again have to show the page 75, my lord. My friend had showed this page, my lord, but I went to show my page 75, my lord. The confirmation of lordship, see, the services of the following assistant teachers of the PB Dhrudatta High Schools are hereby confirmed with effect from the date of their joining as shown against each and against the oath of function and preliminary written by Kalyan Das. He is the first, my lord. And the respondent number 5, my lord, to the petition, my lord, Naren Chandra Deka is number 4, my lord. So my friend wants to show that I am confirmed on only on 12/8/2010. That is not correct, my lord.
This is 12/8/2000.
10, my lord. In the seniority list, I was always number 1, my lord. Until now, it has not been challenged. What my learned friend said that he challenged the gradation list in subsequent proceedings, that is after the judgment, my lord. My lord, next page, lordship, see page 76, my lord. But that then principal has given me a certificate, my lord. Your lordship may see, I just want to read that, my lord, so that the present respondent conduct may be seen, my lord. It is to certify that Shri Kalyan Das, son of so and so, so and so, Assam, was student of MA classes GU Idol Nalbari College Study Center, bearing roll number so and so, during session 2019-20, 2021. He passed MA final examination 2021 in education from GU Idol Nalbari College Study Center, securing first class. The MA first semester exam was held in the offline mode on Sunday only. Due to COVID situation, all MA second semester students were promoted to MA third sem. Class MA third sem exam was also held as per assignment base. After that, the MA fourth semester exam was also held on 25th to 29th October 21 online mode. As per rules of GU Idol during his study, he attended all the classes examination on Sundays and only. So his conduct so. Now, my lord will see, he had made a representation also to the authorities. My lord, he never pleaded seniority, my lord. Lordship may see that at page 91, my lord. Page 91 to 93, Lordship may see he is never, not a single word that he has pleaded his seniority, my lord, over the petitioner. Only thing is that I have not done my MA with the approval of the competent authority. That is his case. Now, if your lordship see the page 94, his appointment, my lord. Lordship may see the word temporarily appointed to act. I'm I'm saying that not. Yes,
Page 91 you showed us. You want any comment from the court? No. Okay.
I don't know. So, my lord, the thing is that, my lord, my appointment on page 40, if your lordship see, lordship is correctly pointed out.
Yes.
Yes. If lordship has correctly pointed out, my lord, page 40, my lord, his appointment letter, the petition, the Kalyan Das, my lord, respondent herein, my lord. Respondent number 1. My lord, that is on the basis of selection board, my lord. It is not, and with pay scale, lordship may say that it is a regular selection, my lord. Of course, the law says, my lord, that if somebody is coming or the back door or without any rules, if somebody is appointed, that then he cannot ask for confirmation, my lord. But here he is a case, a regular selection process was there, pay scale has been fixed, and he has been appointed, my lord. And he has been extended 3 months, then subsequently he was regularized until further orders, my lord. And government has taken it right, then, my lord. The government affidavit, my lord, that he is senior most teacher in the school, my lord. Now, gradation list is seniority list is there, my lord, page 64, my lord. It is signed by, in fact, it is signed by inspector of schools also, my lord. Lordship may see. Inspector of schools, principal secretary, Dhirudat High School. Now he is drawing graduate pay scale from, my lord, 17/9 1998. Whereas the appellant, my lord, 6/11/1998. He never challenged this, my lord. So long. It is signed by inspector of schools and principal and secretary, Dhirudat High School. Now, this order was passed, my lord, lordship may say page 48, my lord. The following in-service teachers of government provincial school under Nalbari districts are hereby deputed to undergo B.Ed courses in government B.Ed college as shown against the name during academic session 2019-21 for 2 years from the date of joining till the completion, whichever is so and so. This is signed by Deputy Director. Oh, during that period, I have done the MA, my lord.
Hmm?
During that period, I have done the MA, my lord. Online mode. Now, law as such, my lord, although he has
Just a
not
moment,
been-
just a moment.
একটু কি আছে?
হালকা বুঝে না ভাই।
এটা গুলো প্রথমে অ্যাডপ ডিগ্রি 2009 দিলীপ না লাগে সঞ্জন তো না লাগে ঠিক আছে কোনটি প্যারা Well, I will rely, my lord, 2009 4 SCC, page 170, my lord.
Just a moment, a small query.
Right.
Because again, an interesting facet.
Yes.
2019 to 21.
Right.
You were deputed for doing B.Ed.
B.Ed.
At that time, you did MA also,
Yes.
correct? You have a certificate that you attended Saturday, Sunday. What happened in for COVID? You had special classes Saturday, Sunday. All those COVID period when we were in under lock and key in our own home. You were attending
Online classes were there, man. Online classes.
Okay.
It's not that physically I attended, but of course that means I've utilized COVID situation very much, man, by studying, my lord.
By studying. Good.
There is no end to education, my lord.
Good. At least you could give an answer. Yes.
Now, my lord, lordship, I want to place first, my lord, 2009 4 SSC, page 170, my lord. Union of India versus Dharampal.
Because your certificate says
Yes.
the MA first session was held in offline mode.
Yes.
It doesn't say online mode.
Offline. Only Sundays and all that examinations are also on Sundays, my
No,
lord.
that's okay, but during COVID, there were physical classes or there were no classes. There is no such certificate. Page 76.
Yes. Was offline moved on Sundays only.
So
Sundays
that's
only.
okay. Offline means not online.
Yes,
So,
this.
I'm on your answer. That's why I said that you at least you gave an answer. Well, the thing is only my bad background.
I know. My lordship may see para 24, 25, 26, and 27
Of
of my lord 2009 4
okay,
SCC
okay.
page para 24 page 170.
Para
Extra copy আছে নাকি?
para
Para 24.
yes.
It is now well settled principle of law, and in respect whereof there is absolutely no quarrel that in view of the decision of this court in direct recruitment class 2 engineer officers association, state of Maharashtra, an employee appointed to a post according to rules would be entitled to get his seniority reckoned from the date of his appointment and not from the date of his confirmation. So that is the basic, my lord, the direct recruitment case, my lord. If your lordship sees 1992 SSC page 7 and 5, my lord, that direct recruitment case. So it is clear, my lord. So then, my lord, there is one more judgment, my lord. 2010 10 SSC, my lord, page 247. 2010 10. Amar. That is, I refer to para 15 to 19 and 19 to 24, my lord.
C.H. Narayana Rao.
Yes. Versus Union of India. Same principle, my lord. There is constitutional bench judgment also discussed in this case. On the strength of the aforesaid constitutional bench judgment, Mr. Para 16, I'm reading, my lord. Mr.
Para?
Para 16, I'm reading, my
16.
lord.
Ah, yes.
Oh, no, para 15 first, my lord. The said question as has been projected above should not detain us long as the same has been considered in the manner or matter of direct recruitment class 2 engineering officers association versus state of Maharashtra by a constitution bench of this court. After an eloquent discussion with the regard to inter se seniority of the direct recruits and promotees, the same has been summed up in para 47. The relevant portion of the said para applicable to the facts of this appeal is reproduced herein below. The sum up, we hold that once an incumbent is appointed to a post according to rule, his seniority has to be counted from the date of his appointment and not according to the date of his confirmation. The corollary of the above rule is that where the initial appointment is only ad hoc and not according to rules and made as a stopgap arrangement, the officiation is such post cannot be taken into account for considering the seniority. B, if the initial appointment is not made by the following the procedure laid down by the rules, but appointee continue in the post uninterruptedly till the regularization of his service in accordance with the rules, the period of officiating service will be counted. So this is clear, my lord. Now, one more judgment I need to place, my lord. That is 2019 5 SCC. That is Deepak Tandon, my lord. Page 573. Here I want to rely on clause para 15.4. My code para 15.4, madam. Fourth, it is settled law that if the plea is not taken in the pleadings by the parties and no issue on such plea was therefore framed and no finding was recorded either by way the trial court or the first appellate court, such plea cannot be allowed to be raised by the party for the first time in third court whether in appeal, revision or writ, as the case may be, for want of factual foundation and finding. So his pleaded case in the, before the learned single judge was that, my lord. It was never the seniority issue, my lord. So there was no foundation. Now my learned friend placed the judgment, that is, place the judgment before this court, but there is matter they have waived the pleading there, my lord, before the single judge, but subsequently it was taken. So pleading is there, my lord. It is cannot be that without a basic foundation he can plead, my lord. Bombay 89 of I think he relied 2007 SCC, 7 SCC 206. It would. Foundation not to be. It will. It will. It will. Okay, do you? Thank you. Who got present? I got present. It was 18, 12, 2000. So, thank you, sir. My lord, because learned single judge already, there are two judgments, my lord, Maushami Sharma and Tankeshwar Nath, my lord. And Tankeshwar Nath, the department has again passed an order, not giving the seniority, but that is also again came to the High Court and High Court has stayed it, my lord.
The reference to these people have come where?
My lord,
The reference to these people have come where? This Tankeshwar Nath.
similar case, my lord. I've given Tankeshwar Nath, I have given that order has been passed, my lord. This order has been passed, and that has been stayed, my lord. Because there was a single bench judgment, my lord, where the order has been passed to consider, my lord, but and this order was passed, then this was also stayed, my lord. That is after Altaf Hussain, my lord. Altaf Hussain. No, no, Department order. I don't know whether I've given the first, Tankeshwar Nath first order, my lord. That is on record. No, no, thereafter, my lord, that stayed, my lord, but after department order was after the first order, my lord, of the High Court. Said that my review. This is the first order. Department has passed an order, then again it has been stayed by the High Court, my lord.
That's all.
That's my-
Yes, anything in reply?
My lord, I have a small reply, my lord. My lord, my friend has, by referring to the confirmation order, my lord, at page 75,
Page
page 75,
75.
senior friend has referred to this, my lord, page, whereby the services of the, my lord, writ petitioner as well as the appellant, my lord, were confirmed. My friend submitted that, my lord, this is not the only confirmation order. This is the only confirmation order, my lord. Prior to this order, my lord, his service was never regularized. His initial appointment was in the very first appointment, my lord, it was specifically mentioned that ad hoc appointment. And it was extended from time to time, my lord, for period initially for a period of 3 months, and the last extension or until further order. So, my lord, this initial appointment cannot be termed to be a regular appointment, like the petitioner. I have referred to the appointment of the
Just a
petitioner.
moment, just.
Now, if your lordship, my lord, peruse the language of the two appointment orders, the appointment order of the petitioner, appellant, as well as the appointment order of the petitioner. Lordship will find that in my appointment order, there was no such word like ad hoc and, my lord, 3 months. And in his appointment, my lord, it was specifically mentioned that his appointment was made for a period of 3 months and it was on ad hoc basis. Had there been any selection, he would not have been regularly, my lord, appointed on ad hoc basis. There was no selection as such. And if there is, for the language, the first line, language of the first line of the order, my lord, lordship, my lord, is confused, then, my lord, lordship may call for the select list basing on which he was appointed. That is one aspect, my lord. The other aspect is, my lord, my appointment is, my lord, page 94, my lord. My, yes. My lord, that is one aspect, my lord. The other aspect, my lord, my friend has relied on two decisions, my lord, 2009 4 SCC 170 and 2010 10 SCC 247. In both those cases, my lord, those persons were appointed on regular basis. On regular basis, only their services were not confirmed. That is why, my lord, the Honorable Apex Court held that, my lord, prior to confirmation, their seniority should be counted. But in the instant case, my lord, prior to confirmation of his service, the services of, my lord, the private respondent herein, my lord, were never regularized. It was on ad hoc basis only, my lord. So, my lord, these two judgments, my lord, perhaps is not applicable in the instant case, my lord. The other judgment, my lord, my friend referred 2019 5 SCC 573 regarding the, my lord, the plea which was not taken in the writ proceeding, my lord. My lord, the appeal is a continuous process, my lord, continuous process of the writ petition. My lord. This is the first appeal, my lord. First appeal. In the first appeal, my lord, Lordship will decide the law as well as the facts. Also, Lordship will appreciate on the relying on some decision, my lord, or I produced those judgments earlier, my lord. Lordship will find the judgments in the record, my lord. And one more decision I am having, my lord. Which is paragraph 8. My lord, earlier, my lord,
We have on record the decision called Satyabrata Datta Chaudhary. This is by you?
no, my lord. My lord, I submitted the judgments of, my lord, Bongaigaon Refinery, Commissioner of Income Tax, and, my lord, MS Starline Agency. These are the three decisions, my lord, on the point of the new plea in the appeal,
Starline Agency.
my lord.
Yes, this is one.
This is one, my lord. Starline Agency, paragraph 20, my lord.
Yes, then
And, my lord, Bongaigaon Refinery, my lord,
Bangkok Refinery. Yes.
paragraph 9. And, my lord, Commissioner of Income Tax, paragraph 10 to 12, 9 to 12. In the instant case, my lord, it is not that those plea was not there in the writ proceeding. The appointment orders of the private respondent herein, my lord, it was there in the writ proceeding also, my lord. That was not, my lord, argued.
So Zakia, we were examining this judgment you have placed before us, my lord. This Bangaigo refinery, my lord. You were referring to paragraph 9, my lord. On reading paragraph 9 and the other relevant uh, introductory facts, my lord, we find that what happened was that there was a land deal. And this respondent in this matter, he was instrumental in taking a decision, but this decision of land purchase was backed by reports of 3 committees. And therefore, the Supreme Court says that although it says on the submission made by the Attorney General that the plea of perversity was abandoned. But since it's an extension of the writ petition is an extension of the writ appeal is an extension of the writ petition, they can still be allowed to take that plea, which presupposes that the plea of perversity was there. It was abandoned and it was taken up again. So it's not a new plea. It's a plea which is abandoned and then taken up again, agitated in the appellate court, and therefore the court says that the decision of the division bench cannot be faulted with, and therefore SLP is not entertained. That's one part. The other decision,
Silent agency, my lord, honorable division bench.
is that Commissioner of Income Tax. Now, please come to paragraph 12. This is a decision in income tax appellate against the order of the income tax appellate authority to the High Court and then to the Supreme Court. Now it says, para 12. The underlined observation of the above passage do not curtail the ambit of jurisdiction of the appellate authorities stipulated earlier. They do not restrict the new additional grounds that may be taken by an SEC before the appellate authorities to those that were not available when the return was filed. So please mark these words.
Yes,
Were not available when the returns were filed. When the assessment order was made, the sentence read as a whole entitles an SSE to raise new grounds, make additional claims, if the grounds so raised could not have been raised at the particular stage. Correct?
Yes.
So in income tax, what happens is that there are many factors based on which the incomes are added or not or rejected by the assessment authority. So therefore, when it goes before the appellate authority in the appellate tribunal, then what happens is that the correctness of the decision of the assessing officer is examined, and therefore the appellate authority may take a decision that okay, in this ground you are getting this addition, in this you get a negative. So that is a ground which was not available at that time when the matter was being examined. So therefore, in appellate court, there's no restrainment to take that plea under the Income Tax Act.
Right.
That is a rough idea of what we are getting.
Right.
So this is not. It does not say that the rule of pleading would not apply in an intra-court appeal. It's an extension. Do you understand? But when it comes to the principles of civil appeal, then we are bound by Order 41 Rule 27. It's very hard for me to get out of those legal jargons. So now additional there's a manner in which additional pleadings are required to be introduced. So because there's again another concept which is now dying, but I'm still holding on to it. You see, that principle is, can a writ petition be said to have been amended by way of an additional affidavit? I have some reservations, but now there are many authorities where it has been accepted. But the fact remains, so far as I am personally of the view, I'm not saying for my brother or for any other, I'm not making any other comment. But you see, when I am appreciating a matter which has civil background. Writ petition is also having a civil background. Therefore, my mind, to my mind, it always comes that the definition of pleadings at Order 6 Rule 1. It says pleadings means a plaint and a written statement. So if that principle in spirit applies in the writ petition, then it is the writ petition and the affidavit in opposition. In one of the cases, I have delivered a verdict where I have said that I have distinguished and I have said that in a civil proceedings, it is the evidence which has to come, which is the basis of a decision. But when it is a writ petition, then affidavit in support of the writ petition itself becomes an evidence, and that can be adjudicated. This is in one of the verdict of the court authored by me. So therefore, I go by the principles of the ingrained, which is ingrained in my mind, is Order 6 Rule 1. Now, therefore, if I take a restrictive view, in my thinking, it's not wrong unless, of course, corrected by the higher authority or a larger bench. But the fact remains that a writ petition can't be amended by way of an affidavit, because a party is not required to respond to an interlocutory application or an additional affidavit when new facts are sought to be introduced without amending the writ petition. But it again depends on the facts on what sort of evidence is being produced in a writ court by way of an additional affidavit. Situation will change when you are reading, when you are referring to a habeas corpus petition. Things may change. So
In this
therefore,
case-
in a habeas corpus application, we don't strictly go by the rules of pleadings, because it is the fact finding which is involved, the nature of prayer made in the habeas corpus, and therefore the court proceeds not on the basis of pleadings, never. The court proceeds on the basis of an inquiry report. So that's why the factual inquiry is being made in a writ petition, therefore there's a departure. So this is one part. Third decision is again similar. It does not say that the principle of the pleadings is waived at all.
My lord, in the same case, my lord, pleadings was there.
No.
Pleadings was there. I have
No,
not
I
annexed
don't
a
know.
single.
He says no,
my
you
lord,
say yes, I have not read.
Accept the impugn order, my lord. Impugn order, my lord. I have not annexed a single document, my lord, and the similar order, my lord. I have not annexed any other document from outside.
Let him
The-
show the pleadings, my lord.
the
Let
appoint-
him show the.
The
pleadings that-
writ petition was we find. Writ petition starts from page 17. Writ petition starts from page 17. It is his pleading, my lord. Up to page 69. The appointment orders has been annexed by him only, my
Yes.
his appointment orders. But those were not considered. Those are not argued. The appointment orders are part of the writ petition only, my.
I'll show you William Shakespeare.
Lordship, his affidavit may be seen from page 77, my lord, whether he has taken the.
Just a moment. I'm just showing you William Shakespeare. Only one line. Man of few words. Don't go up, don't go to there, where I've opened that, only that place. There's a window and then down below, only one line. Hath man of few words. are the best men. So that is what man of few words are. William Shakespeare says they are best men.
My lord, that apart, my lord, the
We'll
appointment,
continue at 2 if required. Mr. Verma, you could step in.
my lord, I will sum up within, my lord, 1 minute.
Hmm?
I will sum up within 1 minute. my lord.
Okay, only 1 minute, then it's
No.
okay. Ah,
That apart, my lord, the appointment of the appellant was my in charge appointment. In charge appointment. Already there is a direction by the learned single judge to fill up the post on regular basis. So, my lord, in the meantime, my appointment as in charge principal should not have been set aside. As it was an ad hoc appointment, my lord, another decision is there on the court that, my lord, ad hoc should not be replaced by another ad hoc appointment. My appointment was ad hoc.
Kyara Singh.
Pyara Singh. Pyara Singh. So, my lord, let the authority fill up the post on regular basis. Till then, my lord, I may be allowed to continue as principal in charge, my lord.
Examine that.
That is my limited service.
Okay, arguments of Mr. I.S. Saikia, counsel for the appellant. Mr. Ms. J. Taranpi, learned study counsel for the School Education Department. And Mr. J. Roy, senior counsel, assisted by Mr. D. Das, counsel for respondent number 5, concluded.
I think respondent number one in
You are
this
respondent number
appeal.
1. Okay, we then write him first, Mr. J. Roy, or respondent number 1. Mr. Taranpi, or 2, 3, and
3 and 4, your lordship.
2, 3, and 4. There's no 5 here.
No, 5.
Okay, 2, 3, and 4. Okay. Just been reserved.
Time being item 1 for admission.
Yes, you were saying something, you were projecting something.
Lordship, Mr. Pang would be appearing in this matter. We spoke to him, so this matter may be taken up some other day.
Some other. When
Thursday?
we take it up next week, because this
Next
week
week.
we have
Next
active
week.
schedule.
Yes, Lordship. Next week would be better.
Yes, Mr. Ahmad, we take it up next week.
My lord.
So all sides are represented. Ms. A. Verma, runner, standing counsel for the Home Department, submits that Mr. J. Pang, learned standing counsel, is entrusted with the brief. She prays for adjournment on behalf of the said learned standing counsel. Post of prayer is allowed. List on 7-8.
Yes,
Can it be an 8 minute?
Huh?
8 will be better than that. Hearing it. Eight.
No, for us, we have every day is a
My lord,
hearing
individual
day.
option.
We are reserving few days for matters. Many miscellaneous matters are coming up. Okay.
7.
Item 2 for hearing.
Ablash. My lord, here in this case, my lord, other day matters heard. My lord, I have prepared a short written argument. my lord.
My lord, the other day, they are from the other side, they are arguing with reference to the judgment of Sarvandar Sonowal on paragraph 26.
আমি এটা পাম নেকি কপি?
ইয়াতো
মোক জেৰক্স লৈ লওঁ, ফটো মাৰি লওঁ,
হুম,
ফটো মাৰি লওঁ।
What is the, which is the document to connect you to your projected parents?
my lord. My lord, here, my lord, the petitioner's claim is that his parents are voter in 1966 and 70. And in 97 voter list against his name, his father's name is there. 97 and 2005.
Just a moment.
My lord,
Which page?
my lord, page, lord, you will find 66 voter list, page 22.
Page 26.
My lord,
What is it of 2005?
my lord, page 22 is the 66 voter list,
22.
annexure 3.
Page 22 is voters list of 1966. This is entry of
Uh, my lord, serial number 238. Father's name
238.
Batsha Sheikh and mother's name Kodbanu Nessa.
yes.
And my lord, against his name in the voter list of 97 and 2005, his father's name is recorded, my lord.
2005. Which page?
It is page 26, my lord.
26.
26. Vernacular at page 27.
You are Jamaluddin Sheikh.
My lord.
Yes.
My lord, my claim is that my positive statement that my parents were voter in 1966, 70 has not been denied. There has been no rebuttal evidence to the claim.
But there is no other supporting documents to that effect.
My lord, is it necessary, my lord? My lord, all linkage should be, my lord, with the documentary evidence, my lord.
You
Evidence-
will tell us, we are asking you a question.
My lord. My lord,
We are posing a question, you have to respond to it.
my lord. Sure.
Well, Mr. Sridhar, if we have to answer it, we have to answer it in the order.
My lord. My lord, I'm sorry, my lord.
No, no, it's not that. I mean, you see, the intention is not to seek an apology. This is the beyond the point. But I'm trying to ask you, it's a code query because if there's no connected documents, is there any pronouncement of this court saying that the voters list is a proof of parentage or a proof of
My
sonship?
lord.
Because of the you see historical background in these cases. Here, what is happening, whether one admits or not, but we see that a singular experience in these few 7 days has shown that singular entries of a voter list is picked up and then said that this is a projected father or projected mother.
My lord.
So because during the such a long tenure of the parentship and sonship, there must be some document to supplement that he is the
My
son
lord,
and father.
My father, my lord, when I became voter, my father is not alive. But my father's name is against my name in the voter list. And another person, my lord, one co-villager has also been examined. He also claimed that,
Because you see, you were born in 1965.
my lord,
So if it is 1965, 21 years would be sometime in 86.
six.
So therefore,
My lord, that is the point, my lord, raised by the other side, that why my name is not in the voter list in between 85 to
because
97.
mother is alive, but it's not in the voter list of 1997. You say in your written statement that you have shifted
My lord,
to some part 2 village,
my lord,
Rakhyasnin, part 2.
my lord. Rakshasini part two.
Hmm.
And my mother is living with my brothers in another village, that is Bharalkandi, subsequently shifted to Bharalkundi. But my submission is that my claim is also supported by one neighbor, that my place of birth is son number 6. He also born in that village. He knows me since his childhood. And my parents are voter in 1965-70. This claim is not been denied. And my point is, my lord, whether non-entry of my name in between 85 to 97 can be fatal to my prime evidence, my lord, when there is no rebuttal evidence, no delineate cross-examination.
Because in this regard, we have many judgments of this court.
My lord, we have also, my lord, judgment. A judgment in Hyder Ali case, my lord.
Which was there?
My lord, Hyder Ali case. Lordship may kindly have a look at the citation is my lord 2021 5 GLT 3. My lord, 3 GLT 85.
2021.
2021 3 GLT 85. My lord. I am here, my lord, relying upon the
2021 3 GLT, page 55.
85. My lord.
65, 65.
85. 85 minutes.
65.
85 minutes.
85.
Para 43, 42, my lord. Para 42. Here there are 5 sub-paragraphs. My lord,
Just a moment. You're getting it. Yes.
My lord, my lord, sub para 3 of para 42. Here, my lord, referring the Sorbonne Sonal judgment, my lord, one may prove one's citizenship without referring accurately to all the factors mentioned under paragraph 26 of Sunwal Supra, my lord. Here, my lord, it should be Sunwal 1, my lord, wrongly typed as Sunwal 2. In Sunwal 2, my lord, paragraph 26 of 1 has been quoted under paragraph 62. So it is wrongly typed. For example, if the date of birth or the place of birth is not conclusively proved, but if it is conclusively proved that father of the proceeding is an Indian citizen, the claim of the proceeding cannot be rejected as a foreigner as it would fly in the face of logic and common sense. My lord, here in this case, my lord, I have mentioned what is the year of birth, place of birth, and my parents' name. If the proceeding father is Indian citizen, then the claim, my lord, cannot be rejected. That is the observation in this case. If it is conclusively proved that the father of the proceeding is an Indian citizen, the claim of the proceeding cannot be rejected as a foreigner, as it would fly in the face of logic and common sense. My lord, very important, my lord, for my consideration, my lord. Then paragraph 4, my lord.
Just a moment. Just a moment.
My lord. Sub-paragraph 4, my lord.
Just a moment. Reading
My lord.
something. Yes, which paragraph?
My lord, sub-paragraph 4, my lord.
Yes.
Further, it is nowhere mandated that he must prove all these facts by documentary evidence only. Section 59 of the Evidence Act 1872 says that all facts except the contents of document or relating records may be proved by oral evidence. There may be cases where the proceeding is illiterate and the birth is not registered with any authority, in which event it would be impossible to produce any documentary evidence to prove his date of birth and place of birth and other facts accurately, and one may rely on oral evidence only. In such case, can a claim be thrown out merely because only oral evidence has been laid?
Yes.
So I also want to refer to paragraph 43 also, my lord.
Yes.
Paragraph 43, my lord, here it may be also noted that the standard of proof in discharge of one of the owners by a proceeding under Section 9 of the Foreigners Act is preponderance of probability, as has been also reiterated in the full bench decision of this court in State of Assam versus Muslim Bundle 2013 1 GLT 809. Thus, the standard of proof being preponderance of probability, there could be minor inconsistency here and there in the evidence of the proceeding, which would not warrant rejection of the claim. This is what the Honorable Supreme Court held in Sirajul Haq case, Sirajul Haq versus State of Assam reported as 2019 5 SCC 534. My lord, here, my lord, the paragraph 4, my lord, says that everything is not required to be, my lord, proved by documentary evidence. When my claim is, my positive statement is not denied as held in the full bench decision paragraph 117.3 and in this paragraph also, they how my lord, my claim, I may be declared as foreigner without, my lord, merely because I failed to produce any voter list with my parents. My positive claims, my co-villagers also says that I am a son of so-and-so. He knows me since my childhood. On what basis, my lord? What is the materials against me, my lord, of the state, my lord? The paragraph 26 of this Sarvadashanal 1 says that when I adduce evidence, when the proceeding adduce evidence, claim that so-and-so is the parents, then they have a duty to verify it and to lead evidence against my evidence, my lord. That has not been done, totally missing, my lord. My name may not be with my parents because my father died long before, and my mother is also staying in different villages. That is my previous case, my lord. And my
You see, there's, you'll have to give one more reply. You can please note down. Please note down
my lord,
case of Vijay Das versus Union of India.
A. Das,
Vijay
Das.
huh?
Vijay Das.
Vijay Das,
This is reported in,
Vijay Das versus Union of India.
yes, 2018 4 GLR 599.
2018 4
4
GLR
GLR 599.
599.
Yes. In this case, the division bench of this court has held. Some and substances of this is that number one, the date of birth is not spelled out of the proceedee, and number two, the no reference to made to the siblings, and therefore, under that facts and circumstances, this division bench of this court has held that written statement and oral testimony in a Foreigners Act would not be sufficient, and it was negated because in this judgment of this 2021, which we are showing, I don't think this earlier judgment of this court has been considered.
My lord. So for the date of birth, my lord, here, my lord, this Hyder Ali case, my lord, there is specifically mentioned, my lord, that there may be cases where the proceeding is illiterate and birth is not registered.
No, that's okay. We are not disputing that. You see, but what we are trying to say is that the previous judgment of the court gives a verdict in a manner which says that the written statement and all evidence is not enough. Now you are referring to Hyder Ali's case. What is the citation of the Hyder Ali case?
My lord,
Hyder Ali.
in the Hyder Ali judgment, paragraph 29 is very relevant. Like, in
Which
this
is that
case.
judgment? The citation?
My lord, same Hyder Ali case. My lord.
2021 3 GLT 85.
Hyder Ali judgment, same judgment, my lord. 2021.
Hyder Ali, yes.
Para 29. Here it is clearly explained, my lord, the strict rule of CPC not applicable.
No. That is the question, in fact. You see this para 29 or this judgment of Hyder Ali does not take notice of the earlier judgment of this court in Vijay Das. Because if the Vijay Das judgment prevails, then the division bench ought to have either made a reference to a larger bench or should have given its own view to negate the judgment of this Vijay Das. You have that citation? No.
My lord, no, I've got
You
this.
please address. We'll take it up tomorrow, day after tomorrow. Please address us on that point. That is the only
My-
point.
My,
You see, the trend of the judgments of this court. That's why in the last week we were not so keen to have a disposal of the matters in the foreigners tribunal because we are finding that there is a shift in the opinion of the court in two times, about 2018 and then later on. There are two tangent views. So we are trying to
My lord.
understand. We are trying to understand
my lord,
the trend of the judgment.
Right.
That is one part. The second part is that we are confronted with a judgment of the Supreme Court of India in the case of MSCT case of Pranay Sethi. In the case of Pranay Sethi, the Supreme Court of India referred, I think I'll forget the paragraphs. It is in the initial part, within 30 to 40. It takes cognizance of the cases of Rajbir Singh and others, and then says that the coordinate bench ought to have taken cognizance of the earlier judgment of the court and the verdict. And then it should have interfered with the or should have given a different finding because it says judicial indiscipline. And therefore the language of the Supreme Court in that case, Pranay Sethi, was a bit harsh, saying that the coordinate bench or the to this bench should have been more forget that language.
my lord, may I know the citation, my lord, Pranay Sethi?
Should have been well advised to refer it to a larger bench if it found that it's not correct. Otherwise, it has to follow the earlier precedent. So therefore, in the law of precedent, there's also judgment of Supreme Court which says that the earlier judgment in point of time shall always prevail. There's a stray judgment of the Supreme Court in about 2015 or 17, which says that the later judgment will prevail because it has taken note of the earlier judgments. But the Supreme Court in Pranay Sethi has made it very clear that it is the first judgment in point of time which shall prevail. Now, with that law in our understanding, you'll have to explain that this judgment of Hyder Ali will still have a presidential value.
My lord, lordship is rightly referring, but one thing is, my lord, we cannot avoid the full bench judgment. In full bench judgment, specifically said, when the proceeding made some claim, positive statements, and there has been no rebuttal statement, rebuttal,
Who is that?
my lord,
Please give that
evidence also.
citation. Give that citation.
My lord,
Please bench.
in that case, my lord, full bench judgment, my lord, 2013 1 GLT 809.
It is Muslim Mandal you are referring
Muslim
to.
Mandal, my lord.
13-1-809.
Yes, my lord.
Okay.
Paragraph 117, lordship, I have only another copy, my lord. 11. আমার একটা condition আছে। লাগিব না? Sorry, my lord, I am only one copy.
It's okay.
117.3, my lord. Yes. Supreme Court division bench or judgment overruled করে দিব পারেন নাকি? That is a wrong judgment. Look to paragraph 26 of the case, same thing as Supreme Court judgment. Full bench judgment says Supreme Court judgment is same. My lord, I think, my lord, Vijayadhar's, while passing the judgment, I have not read the judgment, but Vijayadhar's judgment has been passed without keeping mind of this full bench decision. My lord. Also, paragraph 26 of the Sarvananda Sonal 1. My lord. For Sarvananda Sonal, paragraph 26 also emphasized that the state should verify my claim, my evidence, and also let rebuttal evidence if necessary. That is also discussed in paragraph 26 of Sarvananda Sonal 1 also. My lord. So Vijayadhar's judgment is, I think, although I have not read, but from perception, my lord, I feel that that is also not correct. And that is also in violation of the full bench judgment.
Sarvanan Sonowal paragraph.
Paragraph 26, my lord.
Okay. That's all.
My lord.
Yes, Mr. Sharma.
Regarding the Daniel Lordship, a Lordship has already this about Sarvananda Sonowal 1 Lordship, para 26 Lordship. Lordship, para
5
5 Lordship, 5 SCC 665.
665.
Lordship, para 26, may I read Lordship. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country in order to establish one's citizenship. Normally, he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes place of birth of his grandparents may also be relevant, like under Section 6A1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. If the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. By referring para 26 Lordship, our Honorable High Court Lordship, in a case of WPC 3071 of 2016 Lordship, Zainal Uddin versus Union of India Lordship. Para number was not given Lordship. I am just reading Lordship what court has observed Lordship. This court has held in several decisions that when the citizenship status of a proceedee is questioned that too by the state, it is the bounden duty of the proceedee to disclose all the material facts in his possession at the first instance itself, in this case in the written statement. Failure to disclose material facts in the written statement by itself may lead to draw adverse presumption against the proceedee. However, mere pleading of material facts in the written statement is not enough. If the material facts are disclosed, those would then have to be proved by adducing cogent, reliable, and admissible evidence. Lordship, if
Please repeat the name, Zainal Uddin.
Zainal Uddin versus Union of India.
How is it spelled? Zainal Uddin.
Jainal Uddin versus Union of India Lordship WPC 3071 of 2016.
WPC 3071
Of 2016.
1616.
Yes, Lordship.
Yes.
Date of judgment is 3/4/2018. Lordship. Here in this case, Lordship, proceedee apparently failed to disclose the material facts like that, Lordship. When his father has died, Lordship, when when they have shifted lordship, and regarding that lordship, they could not able to place any cogent, reliable and admissible evidence lordship. Although one link certificate has been placed by the OCD lordship, that was not proved lordship. Again, lordship, my humble submission is that lordship denial is not always necessary, as Sarvananda Sonwal para 26 has already cleared this. Again, lordship, our honorable high court also, in a case of lordship state of Assam versus Wahab Ali,
In Jainuddin, which is the paragraph you are relying on?
lordship,
Jainuddin, what is the paragraph you are relying on?
lordship, paragraph number is not here, lordship, but from page 2 last para to page 3 middle, lordship. I am relying, lordship. If lordship want to see, lordship may see the citation, lordship.
The learned counsel of the petitioner submits that the petitioner is son of late Moinuddin. Is that the paragraph?
No.
How does it start?
Lordship,
Para 4, how does it start?
page 2, lordship.
Yes, I don't have a page, that's why.
No,
You tell us. how
right
does it-
after the italics part, after Sarbananda Sonowal has been
Para
cited,
26.
para 26, after that, we are relying on. This court has.
26 is quoted there,
Yes.
correct? Then,
Then below
Then
that,
below that, lordship.
this court has held in several decisions that when the citizenship status,
just a moment.
that's the paragraph we are relying on, Lordship.
Next para would be the proceeding to the evidence in
After,
chief.
after quotation of para 26, lordship, next para. Yes, lordship. Nine, next to that.
This is in accordance with the underlying policy.
Mm.
Please pass the judgment. I'll
Yes,
find it
Lord.
out. Give to 26. Yep. This is in accordance with the policy. Check
E to put with you. Yung B.
Showing to the evidence in chief. It will have it will have brought to. This code is held in several instances. No. Yeah, it is it to believe. It is the list for this.
Regarding rebuttal, lordship, apart from para 26 of the Urbananda Sonowal lordship, I want to rely on a decision of this honorable court lordship, to WPC 2641 of 2017. State of Assam and Andhra versus Wahab Ali.
You have to give us copies.
Yes, lordship. I am relying para 16 lordship.
What is the name? of the
May I read
decision?
first, lordship?
What's the name of the decision?
Lordship, State of Assam and another versus Ohab Ali. OHAB. Ohab Ali.
OHAB.
Yes, Lordship. 2641 of 2017.
Decided on 29.
Decided on 29/5/2018.
25.
29/5/2018. I am reading para 16, Lordship. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in State of Assam versus Muslim Mandal, reported in 2013 1 GLT 809. Under Section 9 of the Foreigners Act, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevancy to the facts in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevancy, it cannot be said that proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevancy. Lordship. Para 16. I am giving the copy, Lordship.
No, we have it, but we need a printout because
Yes, Lordship.
My lord.
my brother has pointed out, even at the end of the day, if you can make the rebuttal argument, because my brother may not be there tomorrow. So rebuttal argument, we can't give you a date because this
Right.
bench is a stop gap arrangement for the day. On the issue of precedence, that Pranay Sethi, I'll give that citation to you.
Lordship, may
Lordship, I have
fix the
found
case
it.
another
Huh?
date.
Pranay Sethi, I found it. Lordship is National Insurance Company
Ah, yes,
Limited versus Pranay Sethi and others.
yes.
SLP civil, you can take it down.
No, that is report, there's a reported case.
Reported in some other manual which I am not aware of. It's
No, we'll find it out. Just a moment.
Pranay Sethi. It's a 5-judge judgment. Lordship.
If you have the judgment, please see para 36 or 38, something like that.
I have found it. Lordship.
Citation to forward.
Lordship is referring to the per incurium part.
Hmm?
The per incurium. part.
Yes.
Yes, Lordship, I found it.
Citation number 2. Number?
Yes,
You know.
Para 30 and 61. It's para 30 and 61.
Para 29. We are compelled to state, it may differ from your,
Yes,
yeah.
Lordship.
The para 29 says we are compelled to state here that Munalal Jain, the 3 judge bench should have been guided by the principle stated in Reshma Kumari, which has concurred with the view expressed in Sarla Devi, I should be Swarna Verma, or in case of disagreement, it should have been well advised to refer the case to a larger bench. So,
My lord, in the given case, my lord, there are sufficient materials
no,
to show
not on
that,
that. It's a principle, the principle of law.
my lord.
Because if now we are faced with two judgments, you have tried to distinguish by saying that the Muslim Mandal may not have been considered in the earlier case. You are right.
My lord.
Although you did not have access to the judgment, but you are right. Basically, the full bench Muslim Mandal was never considered. So therefore, but the fact is, let us assume that this, for the time being, what happens if the judgment of the rightly or wrongly without considering the Muslim Mandal has referred to the Sarwan Sonwar and given a verdict. Subsequent judgment which you are relying on does not consider that earlier decision. So the principle of per inquirium, you'll have to make your submissions.
My lord. My lord.
Whenever you are ready, please call us, we'll come.
My lord.
We'll take your matter up because tomorrow we can't constitute a bench. It's for the day to day.
My lord, any other day, my lord.
No, this is a special bench.
My lord, I have to go
My-
through the judgment, my lord.
Ah.
I may be given some time, my lord.
No, because this bench is
My lord.
only for the day.
Any other day, my lord, I have to go through this.
No, because we are telling you, this bench is a stopgap arrangement. The regular benches are with Justice Aikia. There's some reason he could not be here today.
My lord, matter is also hard before Soike also. Soike is also present on the other day, my lord.
No, I understand.
So, my lord, I have some difficulty, my lord. I have to go through the judgment, my lord.
So we do not keep it as part of it. We just release the matter.
My lord.
So only one of us in the bench will be a common factor. The, what do you say? I think
Mm.
still we have done an exercise. It was a good exercise. I don't mind, even if the matter is adjourned.
My lord, may I know the, my lord, citation of Pranay Shetty, citation number?
Pranay City, yes, definitely. In Supreme today, I'm very, what do you call, I normally take up Supreme today first.
Right.
So it is para 29 there in the SEC. It will be in a different order altogether. Because here it has been given as per seniority, and in the Supreme SEC, it has been cited on the basis of the strength of bench who has passed the order. So it may differ. Paragraphs may not be same. The citation is 2017 16 SEC 680. But this is a judgment which you may omit to read. It only says that when there is an earlier judgment, that ought to have been followed, or it had to be referred to a larger bench. There's nothing more, nothing less in this, in respect of this per inquiry principle. But the case laws have been cited, but I don't think that would be more relevant. You already know of those principles. For a young lawyer, it would have been a different experience in reading it, but I think you are more experienced. You don't require that. These citations we are returning, you please consult it, and on the next day you'll have to make your submissions again. Noor Begum was given by whom?
Yes, Mr. Payang was given lordship
Acha.
regarding oral evidence lordship.
Ah. We are returning the judgments, please check out who was this. You see, this also, you can give it on the next date.
Hmm?
Also, it's a represented. Counsel for the day is paid for and say AR Siddhar and counsel for the petitioner.
Copy নহলে মোক দি দিও তাহলে চই লব কমপ্লিট এইটো আনি দিয়া নেকি এইটো নহয় এইটো দু yes
My lord,
Single bench of my brother.
my lord.
Realizing. Okay.